So good afternoon and welcome everyone. We are delighted that you were able to join us this afternoon, and also a big welcome to our guest speakers that will be introduced more formally in a few moments. I don't think we need to go over all the Zoom housekeeping details for the last 2 years of Zooming, but do please keep your microphones on mute and use the chat for any questions that you may have that we'll answer those after the presentations are made. So let's start. And Josie, would you be so kind to introduce Laura?
I'd love to. It is my pleasure actually to introduce the first of the two speakers here, esteemed speakers, Laura Southall. In her job as a senior financial advisor with Asante Wealth, Laura works with individuals and families to help them reach their financial goals. She offers seminars aimed at women to empower them to understand their finances. As a real estate investor, Laura has bought, sold, renovated, and rented many, many properties over the last 23 years. To further financial literacy education, Laura is a speaker at many Limestone District School Board schools and classrooms. Teaching young people about money and choice is such an extremely important thing to do. A lot of us, I'm sure, wish that we had that kind of opportunity when we were younger. It made all the difference. So, Laura, we are very, very pleased to have you here. And of course, now, Gabby, could you introduce our lovely second speaker here?
With great pleasure. Angela is an estate planning and administration lawyer in Kingston with 14 years of experience in estate planning. She has focused almost exclusively in estate planning and administration for the duration of her legal career. She was called to the bar in 2007. She earned the Trust and Estate Practitioners designation from the International Society of Estate and Trust Practitioners in 2019 and remains a full member. Angela thoroughly enjoys guiding her clients through some of their more difficult tasks and decisions with regards to their estate and family members. After 5 years of working for a well-established local firm, Angela recently opened Fellow Estates Law. She runs her firm from a beautiful limestone office in downtown Kingston and is happy to be able to bring her friendly dog, Coco, to work each day to lighten the office mood for clients and staff alike. I really like that. It's great. Angela has given countless presentations on various estate-related topics, and most recently gave her second presentation for the annual Probate Essentials course offered by the Law Society of Ontario. Angela enjoys writing lessons, cooking, hiking, and spending time with her family. So thank you both for being with us here today, and the show is yours.
Thank you so much. We're happy to be here. Okay, I will share my screen. So this presentation, I think this is the third I've done for Women Mean Business. This is great. I love your group, and we've had such great questions and such great participation. So Angela and I are really looking forward to this. So transitioning wealth to the next generation and how to leave your money to your family and not the government. We're going to talk about that. So estate planning. People often talk about estate planning, and what estate planning actually is minimizing taxes for your beneficiaries while making sure that your wishes are met. So that's what estate planning is. You hear that fancy name? That's what estate planning is. We're minimizing taxes for your beneficiaries while making sure that your wishes are met. So first, we want to decide on our goals for estate planning, and everybody's situation is different. So you need to first think about what is most important to you when you are estate planning. So Gabby, can we mute the participants?
Yes, I'm trying to here. Could anyone please just check that everything is, that you have muted yourself? There's something. What's today's verdict? Our apologies.
I hear somebody listening to the news in the background.
Yes.
Murdered in a separate trial or sentenced to life in prison.
Just hold on here. I do. So let me show hide. I don't know why that's happening. It shouldn't be because everyone's muted. So I my pardons. Hold on here.
Sounds like it's gone.
Yeah. We don't hear it.
Yeah, we don't hear it now. So hopefully, yeah, our apologies. Please continue.
Okay, sorry. I'm going to have to go back to the share screen here.
Yeah, sorry about that.
That's okay. So when you are thinking about your estate planning, you need to decide what your main goals are. And these can be different goals for different people. Everybody's situation is different. So think what is important to you. A lot of people care about minimizing taxes, but that's just one thing. Is it important to keep your cottage in your family? Is it important to leave enough to your partner to avoid a family law claim, so that things are distributed between your partner and your children? Provide for your grandchildren's education, provide for your disabled child, transition your business to the right person who is often a child, ensure an equal inheritance between children, ensure children from a first marriage receive an inheritance, ensure enough liquidity to pay tax bills. These are all important goals. Your situation is specific, so you need to decide what is important to you. So achieving your estate goals versus minimizing taxes. So these don't need to be mutually exclusive, but you do need to decide what is most important. And Angela and I discussed this when we were preparing for this presentation, but we've seen people who go to such extremes to save on taxes that they miss out on their goals. And if they really knew what had happened, they wouldn't have done things the way they did, but they missed out on achieving their very important goals because they tried to minimize taxes. So you want to make sure that you are achieving your goals while minimizing taxes. They don't need to be mutually exclusive. And we're going to talk about how. So taxes on death. It's really important to understand this piece, and we'll talk first about somebody who has a spouse, because a spouse makes everything very easy. So if you have a spouse, an RSP or a RIF rolls directly to the spouse tax-free. It's lovely. It just rolls right over to the spouse. No tax. A TFSA rolls to the spouse, and the spouse receives the deceased spouse contribution room, which is excellent. Any jointly held assets, so cottage, rental property, any non-registered accounts, bank accounts, roll to the spouse, and any capital gains are deferred. So there's no tax there either. And then the principal residence rolls to the spouse. So this can be very smooth. No tax, it can be beautiful. So that's with a spouse, but not everybody has a spouse. So I just died with no spouse. Now what tax is owing? So principal residence, you're not paying any tax on that. The cottage or vacation property, if you are the last living spouse, there's capital gains on that. Same with the rental property. So those two are both capital gains. If you don't know what capital gains tax is, let me know. Just jump in and ask questions and I'll explain. But probably most people watching this seminar understand what capital gains are. A rough way to, very rough way to estimate capital gains is if you take the sale, what you purchased the asset for. So say you bought the cottage for 100,000 and you sold the cottage for 500,000. The capital gain is the 400,000 in between there. That's the gain. What you actually will owe at tax time is 25% of that gain. That is very rough, but it just gives you a ballpark of what you might owe. So if you died, you bought your cottage for 100,000, you sold it for 500,000, you would owe 100,000, which is 25% of your $400,000 gain. Same with the rental property. It's on the purchase price, not the mortgage amount. People often make that mistake. Remortgaging your rental property does not mean that you make the capital gain smaller. So it's always on the purchase price. Okay, I digress there. So principal residence, no tax, cottage and rental property, capital gains. So your RSP and RIF are taxed as income. And this can be huge. So if you have an RSP with $350,000 in it and you have no spouse, it's as if you just took $350,000 out of your RSP on one day. So you are taxed as if that is income in your year of death. So in that case, that's 54% tax. You have $350,000 in your RSP. That's a lot of tax. People often don't understand that. There is a way to pass on an RSP to a dependent child or grandchild, but there's fine print to that. And if your situation warrants it, we can discuss that. But normally, if someone dies and they don't have a spouse, their RSP or RIF is taxed as income. So if their income in the year was $50,000 from their pension, but they had $350,000 in their RSP, it's as if they earned $400,000 in their year of death. Okay, so TFSA, no tax, tax-free savings account. Non-registered investment, or some people call them open accounts. There's capital gains to be paid on that. Life insurance with a beneficiary, with a named beneficiary, no tax. Income from your year of death, income tax. So this is all the tax that you're going to pay. Now, what about probate? Now, people are often terrified of probate and jump through giant hoops and do crazy things to avoid probate. So you understand, it's actually in Canada called estate administration tax, but when people refer to probate, that's what they're talking about. It is 1.5% on an estate over $50,000. So it's not nothing, but it is certainly not the 54% that you just paid on your $350,000 RSP. So if your estate is $1 million, then you're paying to probate $15,000. So it's not nothing, but it is sometimes worth paying the probate fee to make sure that all your goals for estate planning are being met. So nonetheless, we don't want to pay it if we don't have to. So how do we minimize taxes and probate? So this is a list of the different ways that you can structure things. We're going to go through each one of these and talk about how you might structure this asset so that you don't pay tax or probate. Angela, jump in at any point here.
Okay, I will. You're doing great.
Yeah, jump in at any point. Angela's going to take over at joint ownership because that is more her area. Mine is more the financial area. So RSPs and RIFs, now we know they're taxed as income at death, or they can roll to the spouse at death with no income tax implications. You can list beneficiaries on your RSP or your RIF, and the money will go to them, but then the estate is responsible to pay that tax. So let's go back to the RSP that has $350,000 in it. If that was Gabby's RSP and she named her daughter as the beneficiary, the daughter would get the $350,000, but Gabby's estate would be responsible for paying the tax on that. So if that's your intention to leave the RSP to the daughter, you need to make sure that the estate has enough money in it to pay the tax for Gabby's year of death terminal return. TFSA, no tax at death. It can roll to the spouse at death and the spouse will receive the contribution room. You can list other beneficiaries and they will receive the money in the TFSA tax-free. So no implications. You name your beneficiaries, they get the check. There's no tax anywhere for that. So you want to name the beneficiaries if it makes sense to here. We'll talk about beneficiaries in a minute. So beneficiaries. You want to make sure that you name beneficiaries if that's how you intend to structure your estate planning. So you need to review the beneficiaries on your pension, RSPs, TFSAs, and insurance policies to make sure they're in line with your intentions. And sometimes that means speaking to your advisors, whether it's financial advisor, lawyer, or accountant, and making sure that the beneficiaries you are listing are in line with your intentions. Often people want to leave money to their children, but that doesn't make sense. So listing them as the beneficiary would actually tie that money up until they're 18, and then they would receive all the money all at once at 18. And that's probably not your intention. So you want to make sure that the beneficiary is named and it's appropriate for your intentions. So consider that your estate may need liquidity to pay taxes. So just like the RRSP option, there can be huge tax implications for your estate. You want to make sure you don't name beneficiaries on every asset and then there's no money to pay the tax bill. If Gabby named her daughter on her RSP and there were no other assets, then where is the tax going to be paid from? Eventually, CRA will hunt down her daughter and say, what happened here? And the tax wasn't paid. That's not a good scenario. And that might have taken 18 months for them to get around to that. And now she's purchased a house with her $350,000. So that can be really not a good setup. You want to make sure that there's liquidity enough to pay the taxes. Placing beneficiary designations in your will to protect young beneficiaries. So Angela, do you want to talk to that for a second? Because that is your area.
Yeah, sure.
I sort of jumped ahead in that one.
Yeah, no, that's a really good point. You just mentioned how it can be problematic to name minor beneficiaries on a RSP or life insurance because the effect of that, even if you put someone as a trustee, say I leave my RSP to my children to be held in trust by my brother Bob. Bob has no power to do anything with that RSP or life insurance, and he can just invest the money until the child's 18, at which point they get it all. So instead of that scenario, often the intention is that the asset goes first to the spouse, then to the kids. And if the kids are minors, or even if they're not minors, but imagine a $1 million life insurance policy, you don't want that going to a young adult. So the planning will be such that in the will, the children have a trust to age 30 or 40, depending on the size of the estate and the abilities of the children. So if they're really young, mature children, some parents say everything at 21, my estate's worth 5 million, they can handle it. But often that is not the case. And so we would have the beneficiary designated through the will to be given to the trustee in the will. And then the trust terms in the will apply to that RSP, the life insurance, and TFSA as well, it could. And so the trust terms apply, giving more flexibility and control and fiscal responsibility over that money. And often trusts will have 2 distribution ages so that the kids can learn to deal with money slowly. So rather than getting everything at age 18, maybe they're getting a small amount at age 25 and then the rest at 30. So they get that do-over opportunity to deal with their money, to learn to handle money.
Excellent, thank you. So we make sure the beneficiaries are in place the way that you want them to be. Consider that your estate may need money in it to pay your taxes. Make sure that you have designated in your will how you want to treat young beneficiaries. And then avoid probate if you can by naming beneficiaries for an RSP and TFSA and insurance policy. If you don't name a beneficiary, then those assets have to go through probate. And maybe that makes sense. Maybe that makes sense. I don't know, did someone sneeze, I think. Maybe that makes sense. And so you do need to pay the 1.5% probate to make sure that things go the way you want them to go, or that there's enough liquidity in the estate to pay the taxes. Any questions about that? I know that's a little bit complicated, that section. So don't hesitate to jump in with a question if you have one.
I think you'll see some questions there on your chat if you wanted to, but that's okay. Let's move forward.
Oh, I'm not good at watching the chat while I...
I'll, let me see. Let me see.
Yes, capital gains question. If you do improvements, you can use these expenses to reduce the capital gain. Yes. So keep track of your expenses on the capital gain. Like if you had a cottage and you renovated it, then you keep track of those expenses, and that you can add that to the base cost of your cottage. Okay. That was the only question I saw, and then Melanie.
Yeah, that's correct. Yeah.
Okay. Principal residence. So on death, you don't pay tax on your principal residence, nor do you when you're alive. When you sell your principal residence, you don't pay tax normally, because we have something called the principal residence exemption. So if it's your principal residence, you file the principal residence exemption and you don't pay tax. You could use the principal residence exemption on a cottage if the gain on the cottage, for instance, is bigger than the gain on your house. So you want to, your accountant would do this at the time, but they would look at the cottage and the house and decide which one had the biggest gain and use the principal residence exemption for that property. So I've seen this a couple of times where the cottage increased in value more than the house. So I'm thinking of a client in Windsor. Her mother's house went from 100,000 to 400,000 in Windsor, but their cottage in Muskoka went from 200,000 to 2 million. So they decided to use the principal residence exemption on the cottage because that made the most sense. It was the biggest gain. So then they didn't have to pay the capital gain on the cottage, but they did have to pay the capital gain on the house. So normally you use it on your house, but you can use it on your cottage or vacation home. You can use the principal residence exemption there. So your accountant would run the numbers for you on that, but just to understand that as well. Okay, here we are, cottage vacation home. So the estate will pay capital gains on a cottage or vacation home if you are not using the principal residence exemption. So a good way to estimate capital gains owing is to calculate the sale price minus the purchase price, then take 25% of that amount for the capital gains owing. You can deduct capital improvements to a building, so don't forget to track your expenses if you renovate. So that just answers that question that we just acknowledged as well there. That one's pretty straightforward, I think. Life insurance. So with a named beneficiary on life insurance, there is no tax and it does not go through probate. So if you name somebody, it goes directly to them and it's private and it can pass outside of the will. You might not want to name a beneficiary if your estate needs liquidity to pay tax bills. So I have seen this many times where people have a life insurance policy set up to pay the taxes on the capital gain on their cottage because they want the cottage to stay in the family, but the capital gain will be so big that the children will not be able to afford it. So they put a life insurance policy on the last spouse alive So it's called joint last to die. And it's enough money to pay the capital gain on the cottage. So in this case, they would leave the estate as the beneficiary. And yes, it would go through probate, but then the money would be there to pay the capital gain and the children would be able to keep the cottage. So sometimes it makes sense to have the beneficiary. Sometimes it makes sense to have the estate. But life insurance is a good way to pay for capital gains. And then consider using your will for young beneficiaries. So exactly what Angela has already said. You need to deal with the young beneficiaries in your will, not leave them as named beneficiaries for life insurance or in trust for. Angela, do you want to add to that slide?
Yeah, I was just thinking, you know, I know people get really concerned about probate.
Yeah.
And one easy way to avoid probate on this will, this life insurance that would go through a will for the young beneficiaries, is to have a secondary will. And so a secondary will might cost an extra couple $100 through your lawyer, but it would save the probate tax on that life insurance. So if the life insurance is $1 million, Laura's already indicated the probate tax would be $15,000. The cost of an extra will from your lawyer, like a secondary will, is very small in comparison. So it's one planning technique you might want to ask your lawyer about when you're getting your will redone.
Such a good point. That is such a good point. Especially because life insurance is often a huge asset. Excellent. Thank you for adding that. Oh, joint ownership. This is your area, Angela. Go ahead.
Okay, thanks, Laura. And thank you everyone for listening and for having us. It's really nice to see people, a few of you on the screen, and know that the others are there listening. This is, you know, some of my favorite things to talk about, work related. So joint ownership is one of those things that always makes me think, like, just wait, like, let's take a step back and think about it. Have you talked to your advisors, your financial advisor, your lawyer, your accountant? Because usually people add a joint owner who's not a spouse for one of two reasons. Either they want that other owner to have control of the asset if they lose capacity. So they want, even if they haven't lost capacity, they're just physically or mentally not interested in managing their own assets to the same degree that they used to. So they typically want an adult child to take over. It's the trusted adult child. Maybe they've got more than one. When there's only one child, it's far less problematic. But when there's more than one child, things can get complicated because there's always the question of, well, who owns that asset on death? So this could be a shotgun topic for me. So I'm going to try and stay focused so that you get all the points I'm going to lay down. But mainly the second reason people add a joint owner is to avoid probate, obviously. So they are thinking, well, if I add my adult child as a joint owner on this non-registered investment account worth $3 million or $300,000, doesn't matter, that's going to avoid probate and save the hassle of needing to get probate and to pay probate. But what's not commonly known or understood is that capital gains tax must be assessed and paid whenever a new owner is added, either to real estate or a bank account or an investment account. And so this means that any capital gains tax has to be reported by the transferor in their tax return in the year of transfer. And so there may be a capital loss, but it's more likely that there's a capital gain. And so Laura's already given you the calculation to apply for the tax payable on a gain, but it's just something that people don't think of. So what it equates to, especially with real property, and I've seen this so many times, is that a property was changed hands in the sense that a parent added a child 20 years ago to a cottage, no capital gains were assessed or paid. So then we have to go through the exercise of engaging the accountants and the lawyer and just backtracking to see what capital gains is actually payable and how do we assess and deal with that. And it's just a big mess to untangle. But what it does do, if a joint owner is added, is it creates a bumped up value for future calculations. So that can be helpful or useful. Laura's already mentioned that a principal residence is unique in that at the time of a transfer or adds someone else to a principal residence, no capital gains have accrued to the date of transfer because it's designated someone's principal residence. If someone is added who already has their own principal residence, then the effect of that is that let's just say a child, because it's the most common scenario, is that an older parent adds an adult child as a joint owner on their house to avoid probate. That's the most common reason I see. But that adult child usually has their own home. So what happens is from the date of transfer until the date that child is no longer on title, capital gains tax starts accruing unnecessarily, in my opinion, because there's really capital gains tax is much higher than probate tax, or it can be, depending on the volatility of the real estate market and the duration of time that that child is on title. So if the child's on title for 20 years and the house really goes up in value, we've got a big capital gains tax to worry about. And probate may or may not be avoided. So this may not even be a successful technique, but the probate tax payable on that house will have been most likely much less than the capital gains tax will be. In addition, whenever a parent adds a child on title to an asset, that parent effectively loses control of that asset. So the asset then becomes subject to creditor claims of the child, the adult child. So it could be a divorcing spouse, or it could be some sort of creditor. But there are just a few issues to be aware of. So, joint ownership can become a really simple and really elegant probate planning technique, but it really needs the involvement of your advisors before you go ahead and do it. And so the other thing about adding joint owners, which I think people get really a little frustrated about, is that Laura will tell you, go for it. There's no downside. In her world, there's no downside to adding a joint owner. And you can step in, Laura, if you want to talk about it too. Because as far as a financial institution is concerned, when there are two owners and one dies, the surviving owner owns that asset. No question. Mm-hmm. When the adult child who is the surviving owner comes to me, or to any other estate lawyer and wants to deal with the parent's estate, I say, well, was there evidence at the time of that transfer to indicate the parent's intention? Was that intended as a gift to you, or was it intended as just a probate planning technique? If it was a probate planning technique, were the other required elements in place? And so one of the other required elements is a secondary will. If there are other assets that require probate, then all assets require probate, because the law sees that jointly held asset is actually not the surviving adult child's, but it reverts back to the estate. And that was decided by the Supreme Court of Canada in 2006. So, and has been subsequently upheld. And it's a pretty clear point of law for us. Luckily, in lots of cases, jointly held assets can transfer probate-free to the surviving owner if the rest of the estate is structured in a way that supports that. So if it's going to be a planning technique, it's really highly recommended that you get some advice at the time you want to do that. And I know this,
Angela, can I jump in here with two concrete examples? So sure. One on the capital gains, adding the child, and one on the adding the child to the open account. So in my world, in the financial world, a smooth transition to avoid probate, if there is an only child and one surviving parent, and they generally have a RIF a TFSA, and an open or non-registered account. If there was only one child, we named the child as the beneficiary on the RIF, we named the child as the beneficiary on the TFSA, and we put the child joint on the open account. So yes, it triggers the capital gains on the open account, but those capital gains would have been triggered anyway at some point. So we're doing that now, knowing that everything will roll smoothly to that child on the death of the last remaining parent. So from my world, that looks very smooth and seamless, and that child didn't have to go through probate, and there was no hassle factor. They know that they're responsible for the taxes on the estate and they're going to pay them, and that's fine. What Angela is saying is when there's other assets outside of those assets, something has to go through probate, then everything has to go through probate, including that open account that we put the child's name on. Where they think they're going to get it automatically, they're not going to. So it becomes more complicated with a complicated estate. I've seen it be so smooth where you add the joint owner, that's the child, but there are definitely ways to complicate this. So make sure that you are talking to your advisors about what your specific situation is and what might work for you. Also on the cottage, I just wanted to give us an example because you said quickly bumps up the value, adding the child. What Angela is saying when she says bumps up the value is if Gabby has a cottage that she bought for $100,000 20 years ago, and now she wants to add her daughter to the cottage, the capital gains need to be paid now, but now that's a starting point for the capital gains going forward. So this is a new price now that we have to calculate from going forward if she adds her daughter to the cottage. So it's a new purchase price basically. So you're paying for the capital gains now, and then there's going to be more capital gains later, but that's in the daughter's name. So you're paying tax that's going to have to be paid, but it bumps up the starting point. Is that clear enough, Angela? Is that what you were trying to say?
Yeah, that's true. It is more complicated. If we had an accountant on here, she would be all over it even further because there are some distinctions, but it's good.
Yeah.
Good. Yeah.
I'm just trying to give the rough idea on what is going on there. Sorry, I jumped in.
No, thank you. I appreciate that. Anything that adds clarity. I know sometimes I can get a little hard to understand, which I don't intend. But
it looks like Linda has her hand up, I think.
Yeah. And I noticed there's a question about, maybe that's Linda, but what is a secondary will?
No, yes. I had a question before that. So if I sold my house in town as my primary residence, and I don't pay capital gains, and I move to my cottage and I make that my primary residence, and then in 10 years sell that, what happens?
Do you want me to take that one, or do you want to, Angela?
You can go ahead if you'd like, sure.
Yeah. So while you lived in your house, those years, your cottage, you have to assess capital gains from those years. So the year that you moved from your cottage to from your house to your cottage, from that point forward, now your cottage is your principal residence, but you need to pay capital gains for those years. So your accountant would have a formula to work that out, but you will have to pay capital gains on the years that you weren't living in your cottage as your principal residence. People do that a lot, right? They retire to their cottage. But there still are capital gains to be paid for those years.
But not until you sell the cottage.
Sell the cottage. Yeah. Sorry. Yes.
Okay. So you don't pay the capital gains when you move out there. It's when you, when you sell the cottage, it's from the date.
So if you owned that cottage for 10 years prior to moving to it as your principal residence, you would pay for those 10 years.
So it's really important that you know what it was worth for each year. I mean, essentially the date you move in, you want to have that cottage appraised. So you want the appraised value, get it appraised when you sell your principal residence, and then you'll know, you know, what you're paying the gain on, or what, when you sell it.
Yeah, so an appraisal and your property assessment are very different values, I find.
Yes.
So would I want to use my property assessment value or go the other way with the higher going in?
You want a certified real estate appraisal. So there are 3 ways to value property that, roughly speaking, I mean, someone on the call might have a different idea, but when I'm looking at getting date of death values of the estate, and there's real estate involved, the one way is to get use the MPAC value, which is not very reliable, as we tend to know. Number 2, a certified real estate appraisal of value that you would pay money for. Get a certified real estate appraiser if you're not planning to sell the property, or if you're not ready at that time. That's the next kind of level of appraisal. And then number 3 is just, what is fair market value? And you only know when you sell. So what does the market say the house is worth? That is the best way to obtain value. I hope that helps.
I think so. I think that means that if I had any major renovations to move in, you don't want to do it prior to. You want to do it after it's your primary residence. No, you could do, well, I'm not sure what an accountant would say, but whenever something is your principal residence, it may not matter. An accountant may say it may not matter. If you own that property 20 years, 10 of which you're deeming that your primary residence or principal residence, and 10 of which is your secondary residence. I mean, whatever costs you have to offset a capital gain when it's not your principal residence is ideal, but I'd really seek the advice of an accountant. The main issue is, no matter what, we retain and record all records of capital improvements to a residence, whether or not it's your primary residence, because you don't know what the future will hold. And that was my second question. What is a capital investment? That's something I could send you a link to a CRA website for more details, or you could speak with your accountant. But a general example is just like a roof or something that increases the value. Laura, do you have a comment on that?
Yeah, just think any big renos you want to keep a record of. That's what you want to have in case on all properties, because you don't know. Angela's right. You don't know if you might buy a cottage in 5 years and designate the cottage. You don't know what's going to happen. So always keep a record of any big improvements that you do. Maybe not a can of paint, but you know, you put a deck on your cottage, you put a dock on your cottage, you do the roof at your cottage, you keep a record of that. Okay, thank you. Okay, I think we were on the last point of this slide here.
Yeah, I think we're ready to, we're ready to move forward. I think that last point's pretty clear for people.
Yeah, second death.
Are you in charge of moving? Oh, thank you. Okay.
Sorry. So, I know I'm slow. The slide doesn't react very well. I don't know.
Laura?
Yeah.
Okay, probate. That's of course, one of my favorite topics. And just before, I love talking about probate, and I love defining probate because probate means 2 very different things. So probate is both a tax. So people talk about probate tax, and people talk about getting probate. So paying probate and getting probate are 2 very different things, but they are related. So as we know now, paying probate is actually properly known as estate administration tax. It's not a fee, it's a tax. And as you know, it's 1.5% of everything over 50,000. And then the process of getting probate is actually the process of applying for a certificate of appointment of a state trustee with or without a will. And that's what we refer to it properly in Ontario. And so generally getting probate involves getting a lawyer to assist the estate trustee to make the court application to obtain probate or a certificate of appointment. And somebody asked about the secondary will, and so I'm going to talk about that more.
I also saw a question in the chat about the principal residence exemption if you live in 1 unit of a 6-unit building. So you can claim a portion, you can claim 1/6 of the exemption for if you live in that building. So you're not going to pay the total capital gain, you're going to pay a portion of it. Okay, sorry, go ahead.
Thank you.
Okay, so this slide talks about what goes through probate and what doesn't, and it's very basic and rough and high level, because what actually goes through probate can be a bit of a tricky analysis, and you want to get some advice on that. But when you're doing your planning, when someone's died, you definitely need advice on what goes through probate, but often the whole probate exercise is going to be triggered by a financial institution requiring probate to release the assets of the deceased into the executor's hands. So these days, most financial institutions will require a certificate of appointment before they will release the asset. And that's primarily a liability issue, and that's understandable. The bank wants to make sure they're releasing the asset to the right person. And the court is the place that says, this is the last will of the deceased, and therefore this is the right estate trustee, and therefore this is the right person that the general public, including financial institutions, should be dealing with and can safely deal with without fear of repercussion. A secondary will can be a very useful technique in avoiding probate on some special assets. And I see another question come up, but I'll look at that in a minute. So a secondary will has to be drafted at the same time as the primary will. So if you have a great will already and you just hear me talk and you say, I'm going to go to my lawyer and get a second will because it sounds like it might be appropriate, that lawyer will say, great, I'll do a secondary will for you, but we're going to do a primary will now too. So you do the primary and secondary will together. It's very important that it's done that way. And the secondary will can be used to shelter things like the joint account that's holding assets with an adult child, a first dealings real estate. So that's something that always confuses people. And it is a bit confusing just because it's a very interesting exemption from probate if there's a secondary will. In Ontario, back in the 90s, there was a company called EDS Canada, and strangely enough, I worked for EDS when this government contract was awarded to EDS, and it was called the Terranet contract. And so the Terranet contract purpose was to bring all of the mounds of paper registry documents and scan them into the system, creating computerized records of everything in the registry system, the registry land ownership system. So until that time, as I think a lot of people know, land ownership documents were contained in the local registry offices. And so if you're curious about your property, you would either hire a title searcher or go yourself to the registry office and weed through mounds and mounds of documents. Now, as a lawyer, when I'm involved in real estate transfers, I can just go online on TerraView and I can pull all the information I need. So all that is to say that if you purchased a property and you die with that property, if you purchased the property while it was in the old paper-based registry system and you die still owning that property, then that property can transfer out of your estate probate tax-free if there is a secondary will or if there's nothing else to probate. So like we said earlier, if you need probate for anything, you need probate for everything. If there's only a first dealings real estate property in the estate, then technically that could flow through one will, just a single will, and not need probate. But most of the time, my clients have a little more complexity in their estates, and they've got this and that and all kinds of things. So if we identify that they have a first dealings real estate and they think they might have it on their death, then I suggest a secondary will and see what they say. If they opt for the secondary will because of that, or if they have shares of a privately held corporate shares, so that's common with medical professionals, dentists, anyone who has a medical professional corporation, that kind of thing. Or if you're a business owner and you have incorporated and you own shares in your company and there's equity in that company attached to the shares you own, then those can flow through a secondary will. And so that would not be subject to probate. So when you step back and you think, well, this is confusing, a primary will, a secondary will, I don't get it. Essentially, it's like two doors to the same room. So one person dies owning different assets. The assets that flow through the primary will would be one door into their estate, and the assets flowing through the secondary will would be just like a second door to the same estate. The first door, you have to pay probate tax before you can go through it. The second door, you don't have to pay probate tax before you go through it. But ultimately, usually the terms of the primary will and the secondary will are identical in that all of the assets or the residue is left in the exact same manner. So if you want all your estate going to your spouse and your kids equally, that would be reflected in both wills. Does anyone, I'm going to check the chat for questions on that.
Yeah, I'm just going to check too here. There's one I see. It says here from Diane, if you have bank accounts without joint ownership and everything else is an estate being left to your spouse, what happens to the accounts, and does that trigger probate on the whole estate, including RSPs and house, etc.?
It depends on, so it depends. If the RSPs have a beneficiary designated, then it doesn't trigger probate on the RSPs or the TFSAs. So if you have beneficiary designations on things like life insurance, RSP, TFSA, that beneficiary designation stands no matter what. So the designation can either be on the life insurance policy or the RSP plan or the TFSA plan, or it can be in your will. And either way, it can avoid probate. But a designation is a designation, and those things, unless the estate is designated as the beneficiary, probate tax is not payable on the RSP, TFSA, or life insurance. If the house is left to the residue of the estate and there's no secondary will because it's not a first dealings house, then probate's payable on that. And if the bank accounts don't have joint owners, then yes, they would also go through probate. You can imagine that if there's more than one child, adding just say one child as a joint owner to your bank accounts could be problematic because, as we've said, the financial institution will release those funds without question to the surviving owner. So if there are two children and one child is the surviving owner, financial institution releases funds. The other child says, wait a minute, that wasn't supposed to be just yours. So anyways, it's a bit complicated. If it was intended, just if there was a favorite child for some reason, then, or the finances were intended to go just to one child, then the deceased person needs to leave a declaration of intention showing that that was a gift to that surviving owner, the surviving child, because it's not presumed by law that the surviving owner is the owner. I know, I'm sorry if that's getting complicated. Oh, I should mention there's one other way to avoid probate on assets. When people are over age 65, this is more complex and it's for people with larger estates. So I wouldn't suggest it to anyone with an estate less than, say, $3 million, because say $3 million, you're looking at $45,000 in probate tax. Lots of people believe they do not want to add their kids or whatever to as joint owners on assets. So their assets would otherwise flow through their will. Those assets may not qualify for a secondary will. So I would suggest, what about an alter ego or a joint partner trust? And you have to be over 65 years old. One member of the spousal unit or the individual, if it's an alter ego trust, that's just an individual trust, has to be over 65 in Canadian. And what that involves is retitling the assets in the name of the trust. And one will is generally still required, but probate tax is completely avoided. The trust is private as well. It doesn't go through probate, so it's a private document. And
we have a question here. I may interrupt.
Sorry.
A different topic. What happens to a person's employment pension when that person passes?
I can take that one, Angela, if you want. Technically, there's a survivor pension of 60% in Canada, but often pensions have option sheets when the person, so say Gabby works for Queen's and she's about to retire. When she opts to take her pension, she gets to choose whether she leaves a 60% survivor pension to her spouse, a 75% survivor pension to her spouse, or 100% survivor pension to her spouse. So the default is 60% that you would get the surviving spouse, but there's options that are made at the time of taking the pension that can change that. Also, there can be an option to not leave a surviving pension to the spouse, but the surviving spouse has to sign off on that. So you just want to be aware of what is set up for your spouse.
Thank you. That was good. All right, we might as well carry on. I don't see any other questions right now.
Okay, I'm ready for the next.
Here. Yeah, sorry, I'll move that slide.
Okay, so I think that I've already touched on this. But
we've done this.
Yeah, you can refer to it just to as a summary of what's been said.
Mm-hmm.
Here's another question, if I may interrupt.
Yeah.
Why can you not add a beneficiary to bank accounts?
Yeah, you can't. I know. And same with open and non-registered accounts can't have a beneficiary either. It's just the TFSA and the RSP that can have the beneficiaries.
Right.
Unfortunately. I always bring up gifting when I'm doing this presentation because there's sometimes confusion. You can gift to your children with no penalties. In the US, they have gifting tax. We don't have that in Canada. So if Gabby wants to write a check for $100,000 to her daughter, she can do that. So if your estate is sizable and you want to reduce, you know it's going to go through probate and you want to reduce the amount of probate payable, then it might, depending on your circumstances, make sense to gift some money to your children prior to your death. The upside to that is that it's kind of fun to gift to your children while you're still alive and you get to see them enjoy it and you get to see what they spend it on. And that is fun. The downside is that you want to make sure that you have enough to survive. You don't want to run out of money. And I've seen that several times where money has been gifted in my own family. My grandparents gifted money when they sold a farm that they had, and they sold it for far more than they ever thought they would sell their farm for. And so they gifted to their 7 children, but nobody predicted that my grandmother was going to live till 96 in a very expensive home. And she ran out of money and there were 7 children. So then they all had to come together and figure out how to pay for my grandmother's expensive home, which is not fun. So, and it causes a lot of strife. So if you are going to give to your children, just make sure that you have enough to do that appropriately. Angela, did you have anything to add on that one?
Yeah, that's a really good story, Laura. I love that story. And it's always what goes through my mind when clients say they want to gift something to a child. Mm-hmm. I know it's really gratifying, and I love to see that. And also, lots of people can successfully gift during their lifetime to one or more children. And when they want to do that, they often still intend ultimately to treat their kids equally. So they see one of their two children is kind of struggling more financially or has greater need. So they'll say, give $100,000 as a down payment for a house for a young family, whereas the other child is really successful financially and they won't do the same. So what I suggest, there's always a nice, easy, elegant option to put into your will, which is called a Hodgepot Clause. So if you're thinking, and I always giggle when I say that word because it's so cute, and it's cute and it accomplishes so much. So that Hodgepot Clause is really useful. Ask your lawyer if you do plan on giving during your lifetime to your children, and that can be adjusted for in your will. I know in the States it's different, but we don't have to worry about that.
But what the Hodgepot Clause allows, correct me if I'm wrong, because this is your area, is for an equalization. If Gabby gave her daughter $100,000, and then that can be equalized through the will at the time of Gabby's death. Is that right?
Yeah, through the distribution of the estate. Yeah.
Yes.
That's right.
Okay.
So I tell clients, just keep track in writing of all the things you're gifting or loaning to your kids, and whatever you want to be accounted for upon your death. We'll just go through the Hodgepot Clause. Okay, so POA for property. I often say to my clients that your choice of a POA for property is more important than your choice of executor, because it will affect you directly during your lifetime. So it really helps to understand the responsibilities your attorney will face in acting for you. So the next slide talks about the things that the attorney will do. And so they're going to take physical possession of all your property. They not technically necessarily, but certainly they are absolutely responsible legally for all of your property in the situation where it's black and white. And that's the tricky thing with POAs and with capacity. It's rarely black and white. So parents often lose capacity gradually. And this role is often entered into gradually, which can be dangerous, because from the moment a POA starts acting, so maybe some people on the call are named as POAs or are acting as POAs. So this is really good to know. That from the moment you do your first transaction as a POA for somebody, you need to be keeping very careful records. I encourage keeping time dockets. I also encourage keeping written reasons for decisions that have been made with that person's property. So you decided to sell something or liquidate stocks. Were you advised to do that by the advisor because the market was going to change? Like, what was the rationale for your decision making? Document that, because you may be held to account by your siblings or other beneficiaries under the will. If charities are named as beneficiaries in the will, be careful, because everything you do could be highly scrutinized at some point in time. And you'll have to do taxes, of course. Not only would a POA for property manage the assets for the benefit of the incapable person, but they're going to be also cognizant of any legal obligations the incapable person had to other people, like spouses. And that spouse may be a second spouse and a step parent to the POA. It may be disabled children or anything else that you can imagine. So also, if a POA for personal care is named and it's a different person, the POA for property and personal care would do well to consult with each other. I mean, they have to. And so for good reason, the POA for personal care is making the decision, where should this person be living? And the POA for property is paying for that care. So there needs to be some coordination there. It's always important to get advice because that advice can be paid for out of the assets of the incapable person, and that advice will ultimately save your rear end. If, you know, and so if you've got an advisor telling you do this, or an accountant said do that, and you've documented it and you've paid that person, and someone later says, why did you do that? You say, well, this person who knows what they're talking about told me to do it, and I took their advice. And then you want to also keep clear records, because you may be held to account, especially if the executor is a different person than the attorney for property. The executor wants to know what they're getting and why. So the executor is getting all of the assets of the deceased. And so if someone's been acting in the role of an attorney for property for 10 years or 5 years or 2 years, the executor will want to know, well, I thought mom and dad had X. Why is there only Z? You know, that kind of thing. So you want documents. And you base the POA for property has the power to do anything with the incapable person's property that the incapable person could, but that could be subject to limitations that are set out in the actual document that appoints the attorney for property. So look at that document carefully, review it with a lawyer if you think it's necessary. Always remember that a POA for property is not an agent. So I don't know if the distinction matters that much to you, but an agent has a lower duty to another person. An agent is just taking a simple thing for a designated period of time, and it's usually a designated task, whereas an attorney for property has this very big sweeping obligation to the incapable person that requires honesty, diligence, and good faith. It's actually the highest legal duty one person can have to another. And so it's important. The other thing that's not noted here is that the POA for property is entitled to compensation unless the POA document states otherwise, but the compensation is set out in the law, in the regulations. So that's also why it's important to keep track of your accounts, so you know what was the property worth the date I took it over. You might even want to start getting property appraisals, because that will factor into your compensation. So if there's a real estate portfolio, what's it worth? Find out. And then you can be compensated accordingly.
Very good. Let's see what question we have here.
I'm not sure I can answer that question. Maybe Laura can. I think it's
sorry, good one. I can't see it.
Mortgage company.
What happens upon death of a co-signer of a mortgage?
The bank would ask for a new co-signer, or they would see if the person holding the mortgage was now able to get the mortgage on their own. Okay. They would have to know about the death of the co-signer, which might not come to their attention until the mortgage term is up for renewal. So you might have a little bit of time there, but they would want some sort of proof that the person holding the mortgage would have a way to pay the mortgage. So if they don't have a way to pay the mortgage, they would need another co-signer.
Mm-hmm.
Okay.
Okay. Estate trustee.
Yeah, I think we're almost done here, right? So the next slide sets out the role of the estate trustee.
Sorry, I'm so slow with these slides.
So this is just a bunch of highlights that would...
So just to clarify, when we say executor often, it's like probate, right? Estate trustee means executor?
Yes. So an executor can be empowered by the court to act. They're always empowered by the will, but they may need a certificate of appointment of a state trustee through the court. But yeah, a state trustee is the same as executor, administrator in an intestate estate, personal representative, all of those terms are used. But the estate trustee has a lot to do in the first couple of years after someone dies. And I've listed some things here. So to start off, the executor is entitled to compensation too, unless the will states otherwise. It's a common law calculation that's up to about 5% of the value of the estate at date of death. And but that said, it's not an automatic entitlement. And all of the beneficiaries of the estate have to approve the executor's accountings and the executor's compensation that they propose. So if the estate was worth 5 million and they say, I'm taking 5%, you want to show that the estate had a little complexity, because otherwise that might be seen as a windfall to the beneficiaries. So if Laura was holding that 5 million in an open account and it just went through, you know, and all that was required is, you know, some taxes and general duties, then 5% might be steep. Anyways, before distributing, yes, I should go from the beginning. I'll go quickly because some of these things are obvious, but you know, you're going to deal with the funeral, get some advice, definitely read and understand the will. If you need help with that, you can go to a lawyer. It's rare that people come to me for will readings because although I've had a couple and they're always so fun, I feel like lighting a candle. It's very solemn. But it rarely happens because wills are fairly self-explanatory sometimes. So you're going to take an inventory of the assets and liabilities of the estate as at the date of death. Always docket your time. You might need those dockets to substantiate your executor compensation claim at the end. So always proceed with the end in mind. You may need probate. If so, get it. Go to a lawyer and they'll help you. Sorry, we're running a little over, but I see some people need to leave, and that's fine. That's great. I know we're a little late. So there are three main areas of liability for an executor, and I want to just quickly point them out. Number one, CRA. So pay the taxes before you distribute the estate. Get a clearance certificate from CRA. Number two, third-party creditors. So posting a notice to creditors through an online forum such as Notice Connect. It's the only one that I know of. Will easily extinguish that potential liability within 30 days of posting the notice. And number three, you're liable to the beneficiaries. So again, there's that fiduciary obligation to beneficiaries comes into play. And so throughout the whole estate administration, you're communicating with the beneficiaries, you're keeping them up to date. The way the law goes, there are some kind of automated updates to beneficiaries that they'll receive. Just if you have to apply for probate, they're going to get some information right off the hop. There are new estate administration forms that just came out in January. And one feature of those forms I'm not too crazy about is that as soon as we apply for probate, everyone is notified of the estate.
Sorry.
That's okay. And so, whereas before, executors didn't have to reveal the value of the estate to the beneficiaries as soon as they applied for probate, which is nice because it doesn't set expectations. So if people see, oh, the estate is worth $1 million, there's two beneficiaries, I get 500, that's definitely not necessarily true. There's taxes, there's fees, there's lots of other things. So those new estate court forms have that one major wrinkle in them that a lot of lawyers are up in arms about, and hopefully we'll get that changed. But anyways, you'll open an estate account, ideally one account, and that keeps your estate accounting records nice and clean. You want to invest the assets, but conservatively. You're going to be communicating with the beneficiaries regularly, keeping records of the estate assets. And I often refer my clients to someone who can prepare an estate accounting for them so that at the end of the administration, they've posted the notice to creditors, they've kept the beneficiaries up to date, they've liquidated all the assets, and they've got the clearance certificate from CRA. Now they're ready to distribute the estate to the beneficiaries. They want to be able to have a nice, clean, professional estate accounting to present to the beneficiaries. And it also will have their compensation calculated by that person who's an expert in preparing estate accounts. So it lends more formality and credibility to the estate, the executor compensation calculation. So I like that too. It's not the beneficiary saying, I'm entitled to this. It's the person who prepared the estate accounts who does it routinely, who's saying, this is typical compensation that and then it also shows what each beneficiary is then entitled to. And then the lawyer usually prepares the beneficiary release to go along with the estate accounting. And once the beneficiary is all signed back on those releases, the estate can be distributed, and then you can pop the cork and celebrate a successful completion.
Hey.
Yeah. Oh, were there questions?
Let me just have a quick look. No, it's just, no, that's it. People had to leave. So they're just leaving a message.
Okay. Yeah. So just to wrap it up, the first step is to decide on the goals for your estate. Once you've decided on your goals, then you strategize from there to minimize the taxes for your beneficiaries. So first is your goals, then minimizing the taxes to keep things the way you want them to go. Because Angela and I have both seen things where it goes very far south from what the original wishes were, just in an effort to minimize taxes. And any questions, please reach out to Angela and I. We're happy to answer any questions. And you can follow us on social media.
Wonderful.
Yes, I did see that some people from, and I can see on the screen that there's some people from the library presentation from last week who are here tonight, which is great. Thank you so much. Please follow my social media of this social media, not my personal. I can't accept people to my personal because it's my personal social media.
Of course. Okay.
Any questions?
No, I don't. Gabby, done?
Yeah, I think, go ahead, Josie.
Well, ladies, Angela and Laura, I want to thank you so very much on both Gabby and my behalf. I mean, that was incredibly helpful. I'm hoping everybody else who listened in found it extremely helpful and useful for setting things up properly for their families. I just want people to know that this presentation has been videotaped. It's going to be on our YouTube channel, and a link will be emailed to all the participants that were here tonight. So you're going to get a link to this presentation. So if you want to watch it again, take some notes. Also, the social media information for both Angela and Laura will be in that email as well. And plus, this information will be going out in our newsletter this week. So ladies, your presentation video will be going out to our 1,300 plus readers, and your contact information will be there as well. So people want to reach out to you. But honestly, thank you so very much for this really, really wonderful presentation, especially helpful for me.
Yes, and I also want to say for everyone that through all this multitude of information, it is overwhelming. And I'm so glad that we recorded it. You can go back and listen to it again. But I highly suggest that you get a financial advisor, you get a lawyer, and you get a good accountant to start off with, because there's no way that you could know everything. They are special, they're expert in their field, and that's who you should go to. Yeah. And so I highly, highly recommend that. And if you have a will now and you need it updated, those things are so important. I don't know what percentage of Canadians, I saw a percentage that don't have wills in Canada, and it was pretty high. And it's so important to avoid a lot of complications afterwards. So thank you so much for the expert advice that you've given and the detail of it. And we thank you for your time, both of you. And I thank you, all our guests that were with us. I know there was a lot of information, so I'm glad we recorded, but I'm sure if you have any further questions, please contact them directly.